Hey Rebecca.
How are you?
I'm really good.
So welcome back.
Yes.
We've both got a handful of decisions
Yes.
here.
Yep.
But before we get into that, it's 1 July.
Yes.
Happy new financial year.
Yes.
Of course, the wage increase. Do you mind recapping?
Absolutely. 3.5% increase to both the national minimum wage and to base rates in modern awards. That takes effect the first full pay period on or after the 1st of July. Other considerations, the increase and what that means for annualised wage arrangements under modern awards that provide for it, employment contract questions that might come up. Can I absorb the 3.5% into my over-award payments for certain employees? Well, the answer might be yes, it might be no, it depends on the contract.
Yeah, so quite a few things to think about.
Yes.
And you touched on contracts.
Yeah.
We've had a recent decision from the Fair Work Commission, a very short decision, which are my favourite kind, and it deals with the question of whether this particular employer could offset
Yes.
against a higher wage rate other entitlements that might have been available under the award. And it really came down to what the contract said
Yes.
about that.
Yes.
Do you want to just recap what the issues were here and what the Fair Work Commission said about that?
And I should clarify, it's not a decision, it's an opinion. So the Commissioner wasn't able to make a determination. The Fair Work Commission didn't have the scope in line with the awards, and we're talking about the SHADS award. So she expressed an opinion. But what's really interesting, I find, and the lesson that comes from this, is that a well-drafted contract makes a difference. So it was the Commissioner's opinion in this regard that they couldn't offset. Having a look at the replicated terms, they were almost a little bit contradictory. So one clause said, your pay is inclusive, but you will be entitled to penalty rates, allowances or loadings. But then the next clause says where your pay exceeds legislative minimum entitlements, they may be used to offset. So to my mind, that's not really a clear, unambiguous contract. And it reinforces to me the value of the contract.
Absolutely. It's a really good reminder that offsetting is an important part of a contractual arrangement, and if you're paying above award rates or you've got an annualised arrangement, the contract needs to be really clear about what that is meant to cover and entail and what it can offset. As you say, the value of a well-drafted contract really comes into its own when something goes wrong or is called into question. Another recent example in the Fair Work Commission of that in action was a decision of Commissioner Simpson in Burtis Moores and the trustee for Williamson Family Trust. In that case, an employee refused to provide medical information in relation to an absence and refused to submit to an independent medical examination. The employer ultimately dismissed the employee after they'd gotten into a bit of a standoff and a bit of a email skirmish about whether that was something that the employee had to do, whether the employer could request medical information, and ultimately a decision to dismiss was made on the basis that the employee had failed to follow a lawful and reasonable direction. Procedural fairness was afforded in relation to, the warning that, look, this might result in termination if you don't do this. This is something you should comply with. The Commission found that there was compliance with the Small Business Fair Dismissal Code, which was relevant to this case. But what's particularly relevant to our discussion about contracts is that in his decision, Commissioner Simpson determined that the direction to provide medical information or undergo an independent medical assessment was lawful and reasonable because it was an express term of the contract that the employee do that if required or reasonably required. So another illustration of the fact that employment contracts are not just a nice to have, they actually represent really important rights and obligations for both parties. Exactly. So what have you got for us, Jo?
Now, as you know, I worked in the hospitality industry for a long time with QHA, AHA.
Indeed.
So this is one involving a hospitality business, and it's a decision of Deputy President Butler, and I have to say I do like this decision. It's very quick and very clear. It was to do with a jurisdictional objection about whether an employee had been terminated or whether they had in fact resigned of their own accord. Now, the outcome of this decision was that there was no dismissal, so therefore the jurisdictional objection succeeded for the employer. But I think it's a great indication of communication and how communication can make the difference for a dispute occurring, where we had a situation where the now former employee thought she had been sacked. The employer thought that she had resigned. There was no communication to follow that up. So we were talking about contracts before. All written documentation can help to avoid these sort of incidents.
Yeah,
so both parties had to go before the commission. I know the employer was represented. That would have no doubt incurred some level of consultancy fee. There's a lot of expense, time and effort that's gone to something that might have been best dealt with some good communication at the time.
A good point. Yeah, look, absolutely. What was the name of that case, Jo?
Billy Moore and Amala Australia Proprietary Limited as trustee for Batura, hopefully I've pronounced that correctly, trust.
Right.
So that was back in April.
Yeah, and look, that's something that happens from time to time, and we've had a fairly recent query from a client on this very point of, you know, look, I'm not sure that my employee is coming back to work, but there's been no formal resignation. What do we do? And, you know, depending on the circumstances, it can be tricky to manage. And you've got to remember that the employment contract needs to be formally ended, and usually the contract provides for how that should happen.
Yes.
More often than not, it's with notice, and then provisions about that notice being waived or other things happening. But at the end of the day, it needs to be clearly articulated by one party or the other.